Yep. Okay. Go!
Will you hand me my screen box?
Now go. Preach.
The City of Wyandotte versus Robert Allen, 241508.
Good morning, Your Honor. Mark Watt on behalf of the defendant, Mr. Robert Allen. Your Honor, there is an oral motion that I'd like to make, actually two.
Okay, just a moment. Mr. Allen, your name for the record, please.
Robert James Allen.
Okay, so today's the date scheduled for sentencing in this matter. This was adjourned from April 28th. And, counsel?
Yes, just so the court's aware, Your Honor, Mr. Allen did renew his medical marijuana card. He brought it with him. But the motion is, well, the first motion would be Mr. Allen would respectfully request the opportunity to withdraw his plea based on what I believe to be a perception of my ineffectiveness in representing him during the plea negotiations and his acceptance of the plea. He's, without breaking attorney-client privilege, he doesn't believe that I properly advised him. So the first motion would be to allow Mr. Allen the opportunity to withdraw his plea in the interest of justice if he so chooses. All the witnesses are police witnesses and all the evidence is captured on body cam and video. So I don't think the prosecution will be prejudiced. The second motion.
Well, hold on. Before we move to the second motion, I'm not going to even consider an oral motion to withdraw a plea. That all has to be done in writing, so that the prosecutor has an opportunity to respond.
Understood.
Because this plea was taken on March 12th, so now we're over 2 months ago, and I need to be able to review the motion to determine whether or not that is something this court would grant. And counsel, your next motion.
The second motion, Your Honor, would be, since there has been a breakdown in the attorney-client relationship, I would respectfully move to withdraw from the case so Mr. Allen could either secure new counsel or request court-appointed counsel so that they could properly file a motion. I don't know if they want to file against their hearing or anything, or if the prosecution would be in opposition to it.
Okay, and so counsel, when did this all come about? Did it just come about this morning?
We have been discussing it for a few weeks, and this morning it just came to a head that I can't effectively represent Mr. Allen anymore in line with what he believes to be his best interests as opposed to my conflict with what's happening here.
Okay.
I was retained in a candor with the tribunal. I was retained by a third party who did give me $2,000 to represent Mr. Allen. I proposed that I refund half of that to Mr. Allen at a minimum so that he could.
You refund that to Mr. Allen instead of back to the third party?
To the third party, but basically if they wanted to help him again, I can't in good conscience or refund all of the retainer. I've been down here several times and put quite a bit into this matter so far. So I will be refunding $1,000 to that individual.
Okay, so my question is, counsel, if this was something that was a possibility, why there wasn't a written motion filed before this morning?
I literally believed everything was fine when I was informed of the medical marijuana card, and that it was just the cold feet issues that some of my clients have, and until they give me like clear, unequivocal, I couldn't interpret. I didn't know, you didn't tell me I want to withdraw my plea in any other light than, okay, you're telling me you believe I was ineffective at this point, and what my thoughts were aren't in line with what his beliefs were during these last few weeks. So I do apologize. You're correct that if I knew, I should have filed a written motion, but we discussed it. I said I could withdraw as your attorney, you could find someone else and things like that without getting into the nitty-gritty of it, but it was my belief that the representation was still intact and we were on the same page. And I apologize for interrupting the proceedings earlier. That's when it basically clicked that this is something that I need to bring forth and make these requests.
Okay. Mr. Allen, you have been to court a number of times with Mr. Olata, correct?
Yes.
And you've had opportunity to speak to Mr. Alana on a number of occasions, correct?
Yes.
And you also have had the opportunity to review discovery with Mr. Alana, is that correct?
Yes.
Okay, and Mr. Alana has been your attorney since January, and there's been a number of court dates that have been scheduled. In fact, you all were here April 28th, and we did not hold the sentencing because your client indicated that the CCH was inaccurate based upon what you had represented and requested time to adjourn that to revisit that issue.
And it has been corrected by probation, Your Honor.
Correct. Would that be correct, Mr. Allen?
Yes.
All that is correct, right?
Yes.
Okay, and so now here we are at the date of sentencing and you want to have a different attorney and you want to withdraw your plea.
I don't necessarily want a different attorney, but I want to withdraw my plea because I don't feel, first of all, probation ain't even part of the punishment for what I pled guilty to. I took the plea agreement thinking you were going to sentence me accordingly to what the first offense misdemeanor is for.
Okay, so
You're
what is
trying
that,
to put me
sir?
on
So,
probation and
hold
that's
on.
not even part of the punishment.
Pause just one moment. What is it that you believe is the punishment for a first offense misdemeanor?
MCL 750, whatever else it says on there, the punishment is only 93 days in jail, $300 maximum fine, community service, a 30 to 90 day license suspension, and up to 4 points on your license. I already got the 4 points, I already got the 90 day maximum suspension. I know you're gonna charge me the $300 maximum fine. I feel like that's more than enough punishment for a first time misdemeanor offense. I've never been arrested for anything alcohol related in my life. I'm 48 years old. Never been in trouble in Wyandotte. You're trying to, the clean slate law is supposed to erase my whole record. You're not even supposed to be bringing up my past record on me. The probation department lady already lied on me, put stuff on my record I wasn't even convicted of, putting 12 to 18 months probation. That's not justifiable for punishment for what I did. What I did is, it doesn't even include probation for the punishment.
Your Honor, Mr. Allen's statements to me was I did not disclose to him that probation was a possible sentence. And those
Probation ain't part of the
Stop
punishment
interrupting the
though.
record, Mr. Allen.
So I want to pull my plea because
Stop interrupting the record. Your attorney is speaking right now. Just one moment.
And I do not recall telling him that yes, probation could be part of the court's sentence or that no, probation wouldn't be part of the sentence. I just assumed that Mr. Allen knew that probation could be part of the court's sentence.
Okay.
it's
So
not part of the law.
I understand that, sir. Nevertheless, Your Honor, there has been a breakdown in this relationship and I can no longer in good faith continue this representation, Mr. Allen, not only for the defendant, protecting the defendant's interests, but also now my own interests because I'm in a position where I could be looking at a possible grievance if I continue representation at this juncture.
Okay. Mr. Allen,
Yes, ma'am.
so you're telling this court that the matters that you have on your criminal record, that those have all been dismissed?
No, I said I qualified for the clean slate law and it was my understanding that my past record would not be brought up against me. But here I am. And everything on my record is.
We're gonna take one thing at a time. You understood that you were eligible for the clean slate law. So what does that mean to you?
The lady the representative told me that we went over my record. The CCW on my record, the false report of a misdemeanor, the attempt to receive and concealing, all that was supposed to be erased off my record. It was never supposed to be brought up against me ever again. I was told if I got in trouble again, that none of this would be brought up against me. It would be like I'm getting in trouble again for the first time. So, therefore, the probation
Which
lady.
convictions are those, sir?
Huh?
Which convictions are those that you're speaking of?
The CCW conviction from 1997, the false report of a misdemeanor from 2004, and attempted receiving and concealing from like 2012 or whatever, or 2010 or whatever that year was. All of them are more than 10 years ago. You ain't even supposed to be bringing this up against me.
First of all, 2010 isn't on here.
Well, whatever the year was for
The
the
year-
attempted receiving and concealing.
Okay, that's not on here, sir.
Okay, so well, everything else, so there should be nothing on my record.
That's not true. That's not true.
What? There shouldn't be nothing on my record
Sir,
then.
you have a number of criminal convictions. more than just what you spoke of. In the clean slate law, there are certain convictions that are automatically wiped off per the Michigan State Police, from the Michigan State Police per that law. Sir, the court is looking at some of these, and if you are
trying to prosecute me for my past, say it.
Sir, the court doesn't prosecute. Let's clarify that. The court doesn't prosecute. If you are eligible for any of these convictions, sir, to be removed from your record, then you have to follow the steps that have to occur, right? There's motions to set aside, there's applications to set aside convictions and whatnot. So those are the steps that have to be followed. Some of these are not automatically wiped off.
Can I say something though? I was told since I was a Detroit resident that it does automatically get wiped off. I didn't have to do nothing. The system would automatically update itself.
Okay,
As a Wayne County resident, that's what I was told.
Detroit resident or Wayne County?
A Detroit resident, I'm sorry. As a Detroit resident, if the system was supposed to update itself and erase itself, I didn't have to do nothing.
Okay, well, I have to tell you that's the first I've heard of that. I haven't heard that anything is resident
Well,
specific.
you probably haven't had to go down there and talk to somebody that had your record expunged either.
Sir,
Ma'am?
I'm still given the laws to review when they're passed and then they're enacted. So I don't recall seeing anything about being resident specific. And then why would it be only a benefit of Detroit residents if it's a state statute? So whatever that is, I don't know. I don't know if there's a misunderstanding somewhere. I don't know.
Ignorance ain't an excuse for not knowing the law.
You're correct,
Ain't that
sir.
what you tell me? That's what you would tell me.
Don't presume what I would tell somebody or you. Do not presume that, sir. Now, as well as whether or not probation is something that is a possible consequence, okay? Probation is something that the court would order in lieu. Sir,
Excuse me.
those gestures are not necessary. The gesture of money, money, money,
That's what you
not
want, right?
necessary. No. Probation is something that courts impose in lieu of jail, sir. Now, under MCL 769.5, have you reviewed that one, sir?
No, I haven't.
Okay, well, then I would suggest you review it, because that gives the court judicial discretion if it determines that there is a rebuttal, that the presumption has been rebutted to sentence somebody to probation. Now, if you don't agree to probation, that's your right. And the court also has the right then to impose jail, if that's what the court determines it's going to do. The court also has the right to impose fines and costs only. The court has a lot of judicial discretion, sir, in imposing sentencing. So,
With all due respect, I apologize, Your Honor. I just feel like the recommendation by the probation department is way too harsh for a first-time misdemeanor offense. That's all I'm saying.
okay, and
If
sir,
you
you
want
have the right to
whatever-
have, sir, you have the right to have that opinion.
I
You
just
absolutely have the
wanted
right to that
I just wanted
opinion.
to say that, Your Honor. I apologize. I'm not trying to be disrespectful. I just don't agree with the punishment for the crime. That's all. If you put me on probation, I feel like you're setting me up for failure. That's
And
all.
why is that?
Because first of all, I'm on SSI, my $900 a month is gone before I get it. I don't have no thousands of dollars to give you. My license has been suspended
Let's
for
clarify, you're
90
not giving
days.
it to me, sir. Let's clarify, you're not giving me money.
But I'm saying I don't have any money to give anybody, is what I'm saying. The 90 days, my license has been suspended for the maximum 90 days. I haven't seen my granddaughter, my goddaughter, or my kids in over 30 days. I'm stressed out, I'm sad, I'm depressed, I'm sorry.
Okay, sir, I can understand and appreciate all
I
of
feel
that.
like,
But let me just clarify.
this is my first time.
Let me clarify,
I
sir.
feel like this is more punishment.
This court does not suspend your license. The
I
Secretary of
understand-
State did that.
I understand it, but it's still a punishment, a part of the law of the punishment. And I've gone through that punishment. And now I'm hurting because I can't see my own kids now.
And why can't you see them?
Because my license are suspended.
They can't come to see you.
My son don't have a car. You know what I'm saying? My daughter, she goes to nursing school. She's a full-time mother
Okay, so where does your daughter live?
in Woodhaven.
Okay, and you reside,
I live in Detroit, and it costs a lot of money to take an Uber back and forth that I don't have the money for.
okay, what a bicycle? What about a bicycle? What about somebody
I'm
else?
disabled, I'm gonna ride a bike from Detroit to Woodhaven.
Sir,
You're asking me, man, this is ridiculous, man.
I'm just asking options.
Can I just get a fine and go about my way, man?
And sir,
You're trying to punish me too much for a first-time misdemeanor offense. I've never been arrested for anything alcohol related. This is a 90-day misdemeanor. You're talking 12 to 18 months probation. That doesn't fit the punishment of the crime, man. That's too harsh. Even with the criminal record that I have, 12 to 18 months probation is too harsh. I haven't committed any crime. I haven't been convicted of anything in more than 15 years. This is the first time misdemeanor offense. It should be a fine and my license suspended, and have a nice day, sir. If I come back here again 2 or 3 times to keep drinking and driving, yeah, then I can see getting 90 days and all these probation and all this. But this is the first time misdemeanor offense. I feel like you're being way too harsh on me.
sir, I haven't assessed anything at this point.
But I already know what you're gonna do. I sat in your courtroom and watched you sentence 10 people. And ain't nobody walked out of here with under $2,000 in fines, all kind of probation and everything, bro, for misdemeanors.
Okay,
This guy just got all this for all these probations, and 2 years probation, and he did assault and all this, and you're trying to give me 12 to 18 months probation for a simple misdemeanor?
sir, first of all,
How could they even recommend that, bro?
your conviction is eligible for early discharge. So if you wanted to start comparing the
It's
cases,
not eligible.
stop interrupting me. Stop interrupting me. If you want to compare cases, then you need to have all the facts. You don't know all the facts on every case. This court takes every case, every individual that comes before it, and reviews the report, the recommendation, criminal history, what other special circumstances there are before this court fashions a sentence. Now, it may seem from your perspective that they're very similar, because some circumstances, right, some offenses benefit from similar rehabilitative conditions.
It's a simple misdemeanor charge, man.
That's your opinion, sir, that's fine.
Blown out of proportion. That's all I'm saying.
Well, sir,
If I
you
come
also
back 2 or 3
have,
times.
you also have the
drinking-
option of, after you consume the beers, to have somebody else drive you home, then you wouldn't be here.
You're right. And I really want to go to trial, because making me blow 13 breath flies and charging me with something that with only one, you know, I was falsely arrested anyways. I was falsely arrested. The officer told me, I don't like how you're talking to me. If you don't quiet down, I'll take you to jail for disorderly conduct. That's not disorderly
Okay,
conduct.
stop, you're done, I'm gonna.
I want
have
to
you-
withdraw my plea and go to trial.
Sir, stop talking, please, stop talking. The court's going to grant Mr. Arlotta's motion to withdraw based on the breakdown of the attorney-client relationship as far as, the direction of resolution. It appears that there's a clear, difference of opinion. Mr. Allen, are you intending to retain
Oh, yes,
other counsel?
I'm gonna hire another lawyer. Somebody that's gonna fight for me. I took this plea to be cool, you know? I wanted to go to trial the whole time. I took
Sir,
this plea
you don't need to
under
keep
my
talking.
lawyers.
Stop
Okay,
talking.
I'm just
Stop
saying.
talking. As of now, this is still scheduled for sentencing until this court receives a written motion regarding a plea withdrawn. So, sir, when whoever it is that you're going to be speaking to and retaining, when your attorney sees that on the docket it's scheduled for sentencing, that's because that is what's currently on the docket for procedurally. There's not been a written motion to withdraw the plea. This court's not going to entertain an oral motion because the prosecutor has an opportunity, has to have an opportunity to review the motion and file a response. So we'll adjourn the sentencing.
So I'm not gonna be able to pull my plea and go to trial? I'm just gonna be able to hire another lawyer for sentencing? Or am I gonna be able to?
Sir, do you listen to what's being said, or are you just wanting to say what you gotta say?
I'm listening to you,
What
I'm
else?
asking for clarification.
What I said, sir, was that it's going to be scheduled for sentencing, because that's what's currently procedurally scheduled.
I
There is
understand that
not,
part.
there has not been a written motion received by this court yet.
Okay.
So once there's a written motion, it will be set for a motion date.
Oh,
But as of now, this court's not just going to set it for a motion date, because I have no idea who you're going to retain and what that attorney's strategy is going to be.
Thank you, Your Honor. I just wanted clarification. I'm sorry. I apologize.
You will adjourn sentencing to be June 18th. At 9:30 a.m. That's a Wednesday. And I did that so that in the event your attorney files a motion to withdraw the plea, it will be set on a day that's a wind-down day. So that will be a motion hearing date. Now, sir, I'm sure Mr. Arvada is going to tell you that there's procedure for motions. Notice has to be given, so that you need to retain an attorney sooner than later. If you're in a test right now, sir, what's in your system?
Just marijuana, Your Honor, like always.
And when did you obtain this medical marijuana card, sir?
I went and got it like probably 10 days ago.
Okay, and so did your treating physician, give you any documentation to?
My primary caregiver, she retired, Your Honor, so.
No, sir. I'm
Yes, she
asking your
did.
primary caregiver.
I mean, not primary caregiver, I mean, my primary care visit, my primary doctor that I used to go see,
Okay,
Wendy McKay, she retired, so I don't have no way of like going in and talking to her anymore or nothing, so
okay, when
I
did she
would have to
retire?
get a new, a couple years ago.
Okay, so who have you seen in the meantime?
I haven't seen nobody because they sent me, the new doctor that they assigned me was way out on 14 Mile and something, and I didn't need to go to the doctor since then, so I just never been out there.
Well, sir, the court does not accept a marijuana card from a marijuana clinic. The court indicated that the court already indicated what the requirements
I
were.
told you, a doctor, you can't go into your doctor and say, hey, doctor, can you write me a letter saying you feel like I need to be on weed? Doctors don't do that. You
That's
can't do
incorrect.
that.
That's incorrect, sir.
I don't know what doctor you talk to, but they don't do that.
Sir, I'm not.
I asked my doctor before
I
for
told you
that,
what the-
and that's why I got the card.
Sir.
They don't do that.
Well, you know what? Then we're gonna have to hold a hearing on your card and whether or not that doctor's going to come in to see how long
Let's
that
just
doctor's
handle
been
this
treating
first,
you.
okay?
I'm sorry?
Let's get let me hire the new lawyer, let's go get this, because we can argue about that later, man.
Well, in the meantime, sir, you're probably going to be coming back for a bond violation.
Yeah, okay. I didn't violate my bond. What are you
Sir?
talking about?
Sir, you're using marijuana. That's in violation of your bond conditions right now.
You told
And
me I
once,
can't medical
once you've
marijuana.
been under the
I know.
jurisdiction of this court, the requirements for medical marijuana are clear.
You know I'm using it for medical reasons. You see my paperwork, Your Honor. Why are you doing this? This is what
Sir,
I'm
if
talking
you have
about.
medical reasons, then you would have a doctor that you are treating with that would determine whether or not the medication is appropriate. I'm not going to argue with this any further. If you're testing and you're testing positive for marijuana, then we'll have a bond violation. All right, bonding conditions are continued. Thank you. Have a good day.
Thank you, Your Honor.
Are you kidding me?
Oh my God.
You have got to be kidding me. What? What is going on today? This is a joke. Today is absolutely an interpreter.
I need an interpreter when I cannot express myself somewhere.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Mystery? We're going to start bringing people in first. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
Come and go so fast. Trust me, after today, I'm sitting up here, I'm the one that needs a drink.